Welcome back. Now, the government has released the terms of reference that will guide the constitutional review process to be led by the newly appointed technical committee. Now, according to the Secretary to the Cabinet, Patrick Kangwa, the technical committee, the terms of reference have been handed over to the committee, which will steer the review process, and that the document will soon be made public through national newspapers and the technical committee's official website. This morning, we ask the question whether the creation of the Constitutional Technical Committee was legal or illegal. And to discuss this matter, we are joined by lawyer Linda Kasonde. Ms. Kasonde, good morning and welcome to the Diamond Breakfast.
Good morning, Vida, and good morning to all the viewers out there. It's a pleasure to be here.
A pleasure to host you, Now, you've described the creation of the Constitutional Technical Committee as illegal. Could you start off by just explaining to us why you believe this action violates the law?
Okay, so according to the announcement that appointed the technical committee, the powers that are being used to set up this technical committee are pursuant to Article 92(2)F and 92(2)J of the Constitution. Article 92(2)F gives executive powers to the President to make appointments. Article 92(2)J says that all functions and powers of the President are subject to prescribed laws or the Constitution. So basically, any executive power by the President is not unlimited. That means there must be a legal framework, whether constitutional or statutory, that governs how those powers are going to be used. Now, in this case, the appointment is not subject to any statutory law or any constitutional law that will guide the framework. So in the past, all constitutional review commissions have been appointed pursuant to the Inquiries Act, which gives powers as to how a commission can go about seeking submissions from the public, getting evidence and all that sort of thing from the public in order to compile a report, in this case, on how to amend the Constitution. That hasn't been done in this instance. But let me just also say that the Inquiries Act itself is not a perfect law. It's just that there's no other law that has been prescribed by the government to guide how this civil society has been calling certainly since the last constitutional review process, which was appointed in 2011 under the technical committee. The public has been calling for a specific law that will guide the process and protect the process and the content from political manipulation. So specific law. So in this case, there's no specific law that has been put into place to guide this process, whether under the Inquiries Act or any other law. And you may have seen in the US recently that there have been some protests against President Trump. And this is because President Trump has been making executive orders without the authority of their parliament or without any legal framework to support the executive orders he's making. Similarly here, the president does not have unlimited powers. He can't just decree anything anyhow. For example, if the president woke up one day and decided to appoint the office of the first daughter, surely that would be subject to challenge, because where in our laws or in our constitution does it say you can appoint the office of the first daughter? You see, so the powers have to be checked by either constitutional provisions or a statute.
Do you think also this is where maybe the conversation needs to be right now, before we even look at constitutional reforms? We should begin to also look at, these guidelines that ensure that powers are not being abused, there's no manipulation, and of course, reviews are done within the respected guidelines.
Absolutely, because it almost doesn't matter now whether or not the terms of reference have been released. because the process itself of the committee, of the appointment, is flawed right from the beginning. And if you remember when Munir Zulu and the other persons, the clandestine, I forget his surname, went to the Constitutional Court to challenge Bill 7, they basically said that the process was unconstitutional because the proper consultation hadn't been done from the beginning before the bill was tabled. And therefore, the Constitutional Court said that Bill 7 was a nullity, it was illegal right from the beginning. And so similarly here, if how you set the thing up is not constitutional or is illegal, then the whole process is tainted. You see, it can't be rectified. And maybe just to also say, the technical committee, we don't know, but it seems the government is in a hurry to make these constitutional amendments. And particularly, it seems to be that they want to make these amendments before the next general election in August 2026. So we also are asking, what is the hurry? Okay? And not to mention, the previous technical committee of 2011 took 2 years to go around the country collecting submissions and drafting the report. And in fact, because they knew they were running out of time, they even requested extra time from the president to complete the report. So how is it possible that this new technical committee can go around the whole country consulting everybody at district, provincial, and national level within the few short months before the next general election? I mean, and don't forget, the Constitutional Court said that the reason Bill 7 was flawed was because they didn't consult widely enough. And if this committee is being given the mandate to only consult before the next general elections, that's just maybe, 10 months or whatever it is?
Yes, about 10 months.
How are they going to do all that work within such a short period of time? There's no rush. I think we should just take a step back and go back to the drawing board.
Let's just speak of what legal consequences could arise if the constitutional review process would proceed under this which you deem improperly constituted committee. What consequences would arise?
Well, the appointments can be challenged on the basis of a lack of legality through a judicial review process. Because, like I said, once the process is flawed at the beginning, the whole thing gets tainted. So, I probably believe that's the way to go, to challenge it.
Now, what we're hearing now, and when we're talking of the terms of reference, I know from your standing, us getting here, yes, we're just waiting for the terms of reference to be made public, but the government does say that these terms of reference, this would demonstrate transparency. Does this address bring deeper concerns, or are there issues that are deeper for you that we should be discussing right now?
Absolutely. So firstly, as I mentioned, if from the outset the process under which the technical committee was appointed is illegal, then it doesn't matter whether the terms of reference are released or not. Okay, the process is just flawed from the beginning. But let me also say that on a deeper level, there's a distinction between a technical committee and a commission. Okay, so a commission is a body that is appointed to take submissions from the public and come up with a report as to what the people of Zambia want to see in their constitution. A technical committee is made up of a group of technical experts, so constitutional lawyers and draftspeople who are very familiar with drafting constitutions, who take the reports from the commission and then draft to make sure that the drafting is done properly, in line with what the meaning was intended by the people of Zambia, and to also make sure that there's no ambiguity, any sort of double meaning, or things that are unclear, so that it's drafted expertly to avoid confusion, as we have seen in the past with some of our constitutional provisions. So, in effect, this current technical committee, according to the notice of appointment, has been appointed to consult the people of Zambia on making constitutional amendments. That's the job of a commission. It's not a technical committee. So, I mean, there's that issue as well. And Professor Muna Ndulo has come up with a nice policy brief on what a technical committee should be. And he's also looked at the lessons from the previous constitutional review commissions, amongst them being that there should be a proper legal framework specifically designed for constitution making to avoid the process and the content from being manipulated.
Now, Madam Kasonde, if this process already is so flawed from the very beginning, how do we hold leaders then accountable? Because, I mean, clearly this is an illegality. It shouldn't be going on the way that it is going. But still, this continues to be given life, and it just continues to flow. But this needs to be stopped and then go back to the drawing board. So how do we begin to hold, those in positions accountable? So we can't go ahead like this. This needs to stop. What do we do?
Well, under our constitution, citizens do not only have rights, they also have duties. And one of those duties is to defend and protect the constitution and the rule of law in any country. And so now that people can see that there's a flaw in this process, people can go to court and challenge these things and make sure that the right things are done and that the proper laws are put in place to protect the content and the process. So that's really what needs to be done going forward.
Okay. Now, let's talk on what transparency would look like. Say, in a constitutional review process which is truly serving the people's interests, what would that look like?
So actually, the Oasis Forum in their recent statement has guided as to what a more transparent process would look like. So for starters, before you even appoint the committee, one would want to consult the society as to who should be those technical experts or members of the commission to do this process. Okay, so consult stakeholders in industry, in civil society, on who should be befitting to take up these positions. Then, of course, one should put in place the law that will protect the content and the process from political manipulation, because that is the aspect that has failed us consistently in all our constitutional review processes. We find that the government cherry picks which provisions to put in and which to leave out from what the people of Zambia have said they want to include. So that is undesirable if we really want a people-driven constitution. Then it's up to if it's a commission, they should do comprehensive consultation all around the country and give enough time for people to make the submissions and go to every corner of at least at district, provincial, and national level, which is the golden standard that the Constitutional Court has endorsed. So it should be as broad a consultation as possible. And then if we have a technical committee, let there be real experts to go through the drafting process to make sure that we have a well-drafted constitution.
All right. Well, Ms. Kasonde, thank you so much for joining us on the Diamond Breakfast this morning.
Thank you. It's been a pleasure, and have a lovely day.
You too. We'll be talking to lawyer Linda Kasonde, just speaking to understanding the released terms of reference that will guide the constitutional review process. Of course, it's not yet out in the public, but what the thoughts are there, whether this creation of a constitutional technical committee is illegal or legal, and she has brought out what people need to know. Let's go on a break. When we get back,